Hi guys, it's Kathy. I hope you're doing well. Oh, we made it to the weekend. Yes, sir. We did. Rough week, but we made it through. It's all uphill from here. So, we saw a couple cases in Judge Francisco's courtroom. There were a gang of teenagers that went in to rob a house of guns, and they shot someone and they died, and there were children in the house, and the children saw this happen. We saw two of them, I think, get sentenced. We're going to see I think the last one gets sentenced today, and this one is, he didn't pull the trigger. The person we see today, he didn't pull the trigger, but this one was the worst, I think, of the whole group. And then, but we're going to start off slower, okay? Let's jump into this. I understand his face when you first see him. Don't we all understand? We do. I understand, sir. Don't worry, it's Saturday. We made it through the week. Now it's all uphill from here. Here we go.
State of Indiana versus Michael Eels, 46 D04, 2511 CM 2847. Mr. Eels appears by video with counsel, attorney Mark Woodcox in person. I don't know if either of you, the state, or you, Mr. Woodcox, have received the reports for competency to stand trial.
I have not received them, Your Honor.
All right, I'm going to provide them to you.
I don't do that fast. Those two different reports. Your Honor, it appears that both evaluations determined Mr. Eels to not be competent and recommend that he be sent to the Indiana Division of Mental Health for further treatment.
Your Honor, I'm stopping this right now. That lawyer is fired. That lawyer is fired. I've never talked to any psychiatrist. He's committing perjury. That lawyer is committing perjury. I don't want him representing me. He's fired. I'm leaving these proceedings right now and get hold of the Secret Service today.
All right, let the record reflect that Mr. Eels had a verbal outburst and has left the proceedings. So I think, gentlemen, based upon the reports, both doctors, Mr. Eels failed to...
Judge, he's calling Secret Service on you. You better watch it. You should do something. Beg his forgiveness.
...fully cooperate with. I believe both doctors came to the conclusion that based on what they witnessed in the limited interaction that they had with Mr. Eels, they found him to be incompetent and in need of mental health services. Based on Mr. Eels' conduct today, as well as conduct at prior hearings, I believe the court has enough to refer him to the state mental health hospital for restoration of competency. I believe both doctors indicated that he would benefit from medication, or he's prescribed medication that he either refuses to take or is not taking. So unless there's any objection by the defense or the state, the court's going to order Mr. Eels to be transferred to the Indiana Department of Mental Health for competency restoration services once a bed is available. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No objection.
As far as Mr. Eels' outburst regarding firing his counsel, Mr. Woodcox, you've been appointed in this case, correct?
I have.
So I'm not going to grant his motion to fire you.
Mr. Woodcox objects to that decision, Judge. He wants you to reconsider. The other public defender doing nothing right now. Can he have it?
He doesn't have that option for public defender unless he's going to hire his own counsel. He's not indicated that. So if competency is restored and Mr. Enos
When competency
continues to object to Mr. Woodcox being his counsel, the court will reissue that, I guess, motion or issue at that time. But at this time, I'm going to leave you in Mr. Woodcox as public. All right. Anything else on this one, gentlemen?
No, Your Honor.
All right. Thank
Shocking
you.
conclusion. Shocking. All right, we're gonna go into the child murder trial, and then we're gonna finish it on a lighter note. Don't worry. But we do learn a lot here about how do you try him as an adult? Do you try him as a child? What happens if you do it either way? It all gets explained pretty well here.
All right. This is State versus Zion Gibson, 2504 MR6. Mr. Gibson is in court in custody with his attorney, Mr. Bookwalter. State appears by Chief Deputy Prosecuting Attorney Michelle Galvievsky.
Want to know why I have a censor thing on there? Want to know why? He's 15. And he's been sitting in jail for a while. So this all happened when he was 13, 14.
The record in this case reflects that Mr. Gibson, who was 14 years of age at the time of the offenses, was waived from juvenile court to adult court and was charged with murder, armed robbery as a level 3 felony, and pointing a firearm as a level 6 felony. After a series of pretrial hearings, Mr. Gibson did enter a plea of guilty to count 2 armed robbery as a level 3 felony. The state would dismiss the remaining counts. The parties concede that the court could, in its discretion, sentence Mr. Gibson under the juvenile alternative sentencing statute. If the court instead chooses to sentence Mr. Gibson as an adult, there would be a minimum 10-year executed sentence to the Department of Correction. Again, if chosen to be sentenced as a juvenile, the court is not bound by the 10-year minimum. Now, Mr. Bookwalter, this court continues to have jurisdiction over your client, correct?
Yes, Your Honor.
And Ms. Galvievsky.
Yes, Judge.
All right, now, Mr.
Never again, because I'm mesmerized and I can't take my eyes off that damn circle. Yep, it was me. It was me. Hi, Lacey.
Bookwalter, you did file the
Look
motion
away.
requesting juvenile sentencing
Look away.
alternatives. This court reached out to the IDOC, and there is availability, and I believe that has been filed in the case. Furthermore, the PSI was prepared and filed. Mr. Bookwalter noted a lack of information concerning what was going on while Mr. Gibson was housed in the Juvenile Justice Center. The court issued the order to have probation file a report, which was filed. So, Mr. Bookwalter, turning to you, have you reviewed the pre-sentence investigation as well as the report on the juvenile matters?
Yes, I have, and I've talked to my client, and he's read them, Your Honor.
Are there any corrections, sir?
No, Your Honor.
And Ms. Galvievsky, have you reviewed both?
Yes, Judge.
No corrections?
No, Judge.
And Mr. Gibson, have you reviewed the report, sir?
Yes, sir.
Your attorney tells me there's no corrections. Is that true?
I'm a little confused by the question.
Sure. Did you review the pre-sentence investigation report as well as the supplemental materials that included how you've been doing in the Juvenile Justice Center?
Yes, sir.
Is there anything incorrect in any of them?
No, sir.
Now, Mr. Gibson, as you sit here before me, you're 15 years of age, right?
Yes, sir.
If at any point something is said by anybody in here and you do not understand, will you please bring that to my attention?
Yes, sir.
I want you to raise your
Okay, I know that nobody murdered anybody when they were 15, but we have all done stuff at 15 that would probably have put us away for a little bit. All of us, and Terry Ham's not here. Not Terry. Terry would never. All the rest of us did stuff when we were 15 that probably was illegal. I feel bad. I don't know. I don't feel a certain way. I feel both ways about this kid.
hand. I want you to do whatever to get my attention so that we make sure that you understand everything that's going along, okay?
Yes, sir.
If at any point you want to speak with your attorney, Mr. Bookwalter, you let me know. He's going to hit the little mute button there and you can have as much time as you need to discuss things privately with him, okay?
Yes, sir.
Oh,
Now,
shut up,
Mr.
Bobby.
Gibson, so you understand how this works is the state does not have any witnesses to present, but I understand there is a witness that wants to testify on your behalf. So we're going to hear from that witness first. Once we've heard from any and all witnesses that want to talk, then your attorney, Mr. Bookwalter, is going to make his arguments on what the court should do. When he is done, Ms. Golubievsky is
Okay,
going to make
Terry, I
her
wasn't talking about
arguments
you, though.
on what the state thinks the court should do. When she is done, you will have an opportunity to speak if you want. You're under no obligation to do so, but this is your time if you want to speak. When you are done, I will let you know what the court's decision is. Do you understand the process, sir?
Yes, sir.
Do you have any questions?
No, sir.
All right. With that said, Mr. Bookwalter, go ahead and call your first witness, sir.
Zion Gibson, Your Honor.
I'm sorry, say the name again?
Zion Gibson.
Oh.
Calling him.
All right. Mr. Gibson, go ahead and raise your right hand.
Terry, what city, or if you don't want to give me the city, that's fine. What's the biggest city near you in Maine? Where do you live in Maine? Like approximately. Don't give me your address. Just about. I want to see how long it would take to drive from my house to that city.
Penalties of perjury that the testimony you give will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
All right. I'm going to have you just sit where you are, and your attorney is going to ask you questions. And then when he's done, Mr. Golubievsky is going to ask you questions. Okay?
Yes, sir.
Go ahead, Mr. Bookwalter.
Please state your name for the court.
Zion Gibson.
Zion, we've been over the pre-sentence investigation, is that correct?
Yes, sir.
And then the report from the JJC, is that right?
Yes, sir.
And there's some things that I want to ask you about in that JJC report
Yes,
that
sir.
we've looked at. And one, there is a handwritten outline of the courses that you're taking, is that right?
Yes, sir.
And there, under the math score, it says there looks like an NC did not participate under math. You see that?
Yes, sir.
Do you know what that means?
Yes, sir.
What does that mean?
That I didn't do math.
Okay. Did you do math?
Yes, sir.
What math have you taken there?
Algebra 1, 2, and geometry.
And did you pass those courses?
Yes,
What
sir.
were your grades?
A's and B's.
So as far as that concerned, you don't believe the report's correct, but this piece of paper attached to the report you do not believe is correct, right?
Yes, sir.
You've taken 3 math courses and passed them with A's and B's.
Yes,
oh
sir.
no, I'm not muted. I'm sorry.
And how is school
that
going
was
in
so
general?
rude.
Good.
What do you mean by good? What's your definition of good?
I'm passing.
He said
And
good.
what are your normal
Not
class
good.
scores?
A's and B's. The lowest I've ever had is a C.
Have they offered you to take a GED at this point because
Yes.
of where you're at?
Yes, sir.
They believe you could take a GED, right?
Yeah. Yes, sir.
Do you want to take the GED?
No, sir.
Why not?
Because I want my high school diploma.
So your plan is wherever you end up after this, you plan on actually getting a high school diploma. Is that correct?
Yes, sir.
Now, when you go through there's a section in the report from JJC about your privilege level.
Yes, sir.
And as I count it, about 74.
Houston rush hour traffic can never affect me. Not even a little. Terry, I'd get your house in 8 hours. I bet I could do it in 7 though. I just wouldn't. I go around New York. I don't even have to go through New York. That's not bad. I could be there by breakfast. No, not by breakfast.
4% of the time you're a level 3 or 4, is that right?
Yes, sir.
About 85% of the time you're a 2, 3, or 4, is that right?
Yes, sir.
How do you get down to a 1 at times?
The variety and the type of write-up you get.
What do you do if you're a 1 to get to a 2, to a 3, and to a 4? What have you done to get to those levels?
Just assisting staff and residents, tutoring residents in school and cleaning and taking out trash and doing things that I wasn't asked to do.
And have you been able to get those up kind of the highest scores at times?
Yes, sir.
Have you been in any fights or anything while you've been in there?
No, sir.
Have you had any trouble while you've been in there?
Yes, sir.
And what does the trouble come from?
Can you arrange that, please, sir?
What you testified in this trial, is that right?
Yes, sir.
I've been called to be out there at times. What happened as a result of you testifying in the trial?
I was getting called names.
Who called you names?
Staff and other residents.
What name were you called?
I was called rats.
But you went in and testified anyway, is that correct?
Yes, sir.
Now, Latrell Vaughn, he was also housed there, is that correct?
Yes, sir.
You've known Latrell how long?
Apparently 3 years. Well, I'm sorry, 3 years.
And how did you meet Latrell?
Through a deceased friend.
What do you mean a deceased friend?
He's dead.
How did he die?
Gun violence.
And where did you meet Latrell at?
A balloon release.
A balloon release for this deceased person, is that right?
Yes, sir.
And how old were you when you met Latrell?
12, about to turn 13.
State of confusion. Yeah, I know.
You obviously, from going through the discovery, you knew a lot about guns, is that right?
Yes, sir.
Where did you learn this information, this knowledge, this ability to deal with guns?
Latrell Vaughn.
And how did you get that information from Latrell?
He taught me and told me what the best things was about them, how to use them, and which ones was the best and how to shoot them.
Did you get a gun that was your own gun?
Yes, sir.
Where did you get that gun from?
Latrell Vaughn.
What kind of gun did you get?
It was a Smith & Wesson.
So do you know you're not going home today, right?
Yes, sir.
You know you're going somewhere, whether it's prison or the juvenile facility. I guess there's two sides of the juvenile facility and prison. You're going to one of those two, is that right?
Yes, sir.
What are your plans?
To do my high school diploma and find myself a trade so I could set myself up so when I'm out, I could do good for myself.
It takes 7 hours to drive from Pennsylvania east to west, or west to east. So I would be out of the state in 8 hours, but 7 hours I would still be in the state.
What trade or what are you good at? I mean, what is your God-given gift to be good at something?
I like cars. I like to use my hands.
So is it more of a mechanical area you'd like to get into?
Yes, sir.
What about the coming back to South Bend, Indiana? Have you thought about that? Your mother's
I would
here
be
in the
at her
courtroom
house
today,
every
is that
day.
right?
Yes, sir.
What do you think's in your best interest?
To leave Indiana in general.
Where would you like to go?
Mississippi.
Who's in Mississippi?
My oldest brother.
What's your oldest brother do?
He's a mechanic. He has his own shop.
Has there been conversations about you could go down there and learn the trade from him at some point whenever you're out?
Yes, sir.
You also are on medications, is that correct?
Yes, sir.
What medications are you on?
Prestige, hydroxyzine, and melatonin.
When did you start getting these medications?
Roughly 3 months to 2 months after I was incarcerated.
Why are you on these medicines?
For overthinking thoughts and so I could sleep at night.
That's all I have, Your Honor.
Skolioski, do you have any questions?
I do. Zion, your attorney had mentioned your grades. I think it was that John Glenn Middle School that you went to before?
John Young.
John Young. But you were expelled from John Young, correct?
Yes, ma'am.
Okay. There was some sorts of incident or altercation or something that happened and you were removed from school, correct?
Yes, ma'am.
Okay. And you were then instructed to do an online schooling, right?
Yes, ma'am.
Okay, but you weren't keeping up with the work, you weren't logging in or anything like that, correct?
Yes, ma'am.
Okay, and it actually was one of the reasons why you were violated for probation was because you weren't completing the schooling that you were required, right?
Yes, ma'am.
Okay, and you were also violated because you had tested positive on a couple of drug screens, right?
Yes, ma'am.
Okay, and we talked about kind of handguns, etc. You sat through your waiver hearing at the JJC, correct?
Yes, ma'am.
And you saw the information that was taken out of your phone and entered in as exhibits at that time, right?
Yes, ma'am.
And that included pictures of numerous handguns, correct?
Yes, ma'am.
Including the handgun that was used in this offense or during the robbery, correct?
Yes, ma'am.
And that was actually from your own house, right?
Yes, ma'am.
So that gun was actually taken from your own residence and not given to you by Latrell, right?
Yes, ma'am.
And there was other messages in there about either smoking weed or anything like that, correct?
Yes, ma'am.
Okay. And so you had kind of exposure not only to the gun that was used in the commission of the robbery, but you had exposure to other handguns, right?
Yes, ma'am.
Okay. And you were trying to get more guns in this situation. That's why you guys went over there, right?
Yes, ma'am.
Okay. And we talked about, I think, Mr. Bookwalter mentioned some kind of like your ranking and behavioral stuff, but there were some behavioral issues that popped up since you've been in custody, right?
Yes, ma'am.
That don't necessarily have anything to do with you testifying, correct?
Can you rephrase that?
Sure. Were there some other behavioral reports that were made about like not listening to what people were telling you to do or like listening to instructions while you've been in the JJC?
For those reasons I was wrote up?
Yeah.
Yes, ma'am.
And there were kind of reasons that you were wrote up about other things like not getting along or maybe disrespecting other people that were done before you testified, right?
Yes, ma'am.
Okay. And some of those behavioral issues actually happened before you even made it on over to before you were waived and started appearing before Judge Francisco. Is that fair to say?
Yes, ma'am.
Okay. I have no other questions. Thank you.
Bookwalter, any redirect, sir?
No, Your Honor.
All right. Mr. Bookwalter, do you have any additional witnesses, sir?
No, Your Honor.
All right, and Ms. Goldashki, you already told me you have no additional witnesses, correct?
No, Judge.
All right, Mr. Bookwalter, what should we do in this case, sir?
You hit around the head, Judge. If it's an adult, it's 10 to 16. If it's a juvenile, it's more indeterminate what the sentence would be. I'm not an expert at juvenile. I understand that based upon your sentencing, he could go to Pendleton to two different sides of the equation. There's the group that are just housed until they become adults. And then there's more of a rehabilitative side is the other side. Both of Pendleton's my understanding. The statute doesn't provide what the test is for you, I believe. The case law does. And the leg case, and I just read a case that came out a couple weeks ago, March 30th, the Guy case, laid those things back down. Number one, the severity of the acts or whether it's part of a pattern of acts. Number two, whether the child is beyond rehabilitation under the juvenile justice system. And number three, whether it's in the best interest of the community that he be sentenced as an adult. That seems to be the three things. And that's not an exclusive list, but that's what the cases seem to always refer to, those three things. The severity is very severe. A life was lost. You sat through the trial. You not only heard Latrell Vaughn's trial, you heard him testify in that trial. So you knew exactly what his role was. And I think he was very honest what his role was. I don't think he minimized it in any way. Whether he's beyond rehabilitation, if you're looking for perfection from a kid that came to the life he's had, you're not going to find it. But he has made some big efforts. And you've got a 16-month period that you could judge him a little bit. This thing's dragged on about 16 months. So you've got going on a year and a half of what he's been like. And is it the best interest of the community? Safety is probably the issue, I would think. Is it safe to have him at some point out in the community? Those are the things that the court has to decide. The PSI, I have one major disagreement with the PSI, and that it lists no mitigating factors. And all of these cases about juveniles list the number one major factor as having the mitigation being the fact that the kid's 14 years of age, and 14 years of age by 22 days.
I don't look at the probation's thing on mitigation, but I understand what you're saying.
Yeah.
I'm gonna let you keep making your argument.
Right.
I just want I want everyone to be clear that if probation's saying there's no mitigation, I'm not saying there's no mitigation.
Right.
And I'm quite confident, Mr. Bookwalter, you're gonna tell me what all the mitigating factors are.
And I'm gonna give you my opinion as to what they are. He's got 2 priors. He's got a joyriding at the age of 10. No gun was involved in that case. He's got resisting with a vehicle at the age of 13. No gun was involved in that case. The picture that's painted, and mom means.
So that was like a little over a year ago. He just turned 15. So 13 wasn't that long ago.
Well, the last thing in the world he needs to do is go home to his mother. He doesn't need that. He has no dad. His one brother's in prison. He's basically, if you read the pre-sentence investigation, he's been running the streets. This thing happened on a Wednesday night in January at 8:45 was when the 911 call happened. Okay. Where's your kid at? Why do you not know on a Wednesday night where your son is and why he's with a 17-year-old with guns involved? And why does he have a gun in his own house?
Maybe
There's
he
no
was just
excuse for
getting
that.
high. Did you ever think about that?
His role model became Latrell Vaughn. Latrell was 4 years older, 17-year-old with a 13-year-old is a big difference at that point. He became sort of the male figure in his life, the male role model. He wasn't going to school. He was failing grades. As the prosecutor pointed out, he only logged in for 96 minutes. He was drinking heavy. He was smoking marijuana, and he tried meth. That's the picture of his life before this happened. And he'd been introduced to this gun culture. And talking to him, he can tell you more about guns than Ben Blatt knows about guns. I mean, he has all kinds of knowledge about guns. Amazing for somebody that age. But what has he done since he's been arrested? He's cooperated.
Right there. Okay, one of those two. All right, there's 2 men to the left and then a lady in the first row. That could be his mother or the lady directly behind her. One of those 2 people is his mom or his mommy. That's English.
He showed up in this courtroom and testified in that trial. And he did it when he was getting threatened. We knew he was getting threatened. We were called out there when the threats happened, and he stayed and testified in the case. He did not diminish himself. He was called a rat. His conduct's been good. It's not perfect. Again, if you're looking for perfection, where he came from, you're not going to get it. But I calculate that 74% of the time he's a level 3 or 4. 85% of the time he's a 2, 3, or 4. And if he dipped to a 1, he dug himself out by doing things. He's never fought. His grades are A's and B's. He doesn't want a GED. He wants a diploma. The mitigating factors, as I see it, number 1 is his age. I mean, my oldest grandson is a month younger than he is. This happened halfway through your 8th grade year. He was born on Christmas Eve, and this happened January 15th. He had been 14 years of age for 22 days. He's 5'10" now, but the Supreme Court does all these studies and they talk all they can about the juvenile brain. He's not a 17-year-old at this point. Huge difference. He's barely 14 years of age. He's had no structure. He's had no rules. He's had no parenting. And when he had that structure and rules, he's done pretty darn good for him. I can't imagine the judgment. Even I had parents that knew what my grades were, came to my sports games, came to band practice,
ball.
did all those things. And I did stupid, and I had a brother, you're older than me, who did real stupid stuff with the same upbringing, but without that. So the second thing.
I sent my younger sister to juvie for 3 years when she was 15 because I called the police grand theft auto. She stole my babysitter's car.
I would point out
I'm sorry, I said that wrong. I was the babysitter. And this was the woman who hired me to come to her house to babysit her kid. And my sister came and stole her car.
mitigation is cooperation. He did it at a risk and he did it. Third, in his 2 priors, he had no history of gun violence. Fourth, he's got a very poor family life. Fifth, I believe, is his conduct since his arrest. 6 is his schooling since his arrest, how well he's done. And 7th, he's genuinely remorseful. My story about that is I took all the discovery out over a number of times. And when I got to the pictures at the scene and the deceased dead, okay, he freaked out. He couldn't do it, couldn't look at it. And that's when he started getting medicated. And to me, you got to be remorseful and you got to have a conscience if you need medication to be able to chill out and even go to sleep at night. And he has that remorse. So I think the decision for the court is this sort of nature or environment. Is he inherently just a bad kid? Is he just that one bad egg that you can't make good? I would make the argument to the court, if you look at the record, it's environmental. It's how he's been raised. And under the right conditions, he can do much better. So I'd ask the court to take a chance on him, take a risk, watch him, make him earn his way out. To me, whatever the court does, the key to that jail is in his hands.
I can't remember.
And he and I've talked about
what
that.
kind of car it was.
Is he BSing us? Is he playing a con game on all of us for the last 16 months, been pretty good, or is that who he really is? And I really think in the juvenile side of doing this that you can watch that and you can see if he earns it or not. You can see if he really means it or not. In the perfect world, if I was sitting in your shoes, I wouldn't want him home. I'd want him to about 18, where he's a grown man. He's ready to go out on his own, not have to move back in the environment he's in. God help us if he does. I don't like that idea. And he can go somewhere and start a life and be that person. So that's our suggestion, Your Honor. I think he's worth a risk. Thank you.
Mr. Buckwalter. Ms. Golubiewski, what's your thoughts?
Thank you, Judge. I agree with Mr. Bookwalter that there are a number of mitigating factors in this case, including Mr. Gibson's age. He was 14 years old at the time of the offense. Mr. Gibson did cooperate in connection to this case. However, the state would argue that he also received a great benefit from the plea that was extended to him in this matter. And what we heard through Mr. Gibson's testimony and the evidence that we saw at trial, there are a number of aggravating factors, including his prior criminal history or delinquent behavior. He does have a prior adjudication for criminal mischief. He has a prior adjudication for resisting law enforcement. He was on probation for that case in 71 JO1 2404 JD 141 at the time of the commission of this offense. In addition to the commission of this offense, Mr. Gibson had a number of violations, one being failure to complete online schooling, the commission of the new offense, and testing positive for marijuana on multiple drug screens whilst on probation. He did exhibit delinquent behavior. If the court would review the order that was attached to the PSI from the waiver hearing, it did note that the magistrate Polando at the time noted that he was enrolled in online schooling because he was expelled from school for threatening to harm other students. At the time that he was enrolled, between August and the time of the offense, which was about 3 or 4 months, slightly more, he had only logged in for 96 minutes. He was failing all of his classes. The court also, in its waiver order, had indicated that it received other behavioral related incidents while in the care of the JJC far prior to even communications or conversations began regarding testifying in this case as well. And as the defendant had noted, there was evidence that was presented at the waiver hearing that showed that the defendant had access to firearms, easily accessible firearms, including out of his own home, and other firearms listed in his phone as well. There were 4 minor children present at the time of the offense. That we know that the children that resided at the residence, some younger than Mr. Gibson, although Mr. Gibson appeared to be younger than most. And I think the nature and circumstances of the events that led up that day, he was ultimately the individual that orchestrated or linked everyone together to carry this out. There was no evidence to suggest that he was forced or told by Mr. Vaughn to do this. In fact, it seemed that they were both acting together. It was his girlfriend's home that they went to. It was a friend close to his girlfriend's that they went to. He set things in motion. And he believed that he was going to get away from it because during the trial he testified and he said, I didn't think they were going to call the cops. They didn't think that they were going to get in trouble if they went to a house full of kids and stole guns at gunpoint. We also know that he had shown off the firearm as well afterwards when he had gotten it. And the most egregious thing to the state is that at 14 years old, he was armed with a weapon from his own home to go and acquire additional weapons. And that is very concerning to the state. I understand that Mr. Gibson has made changes, that he has been excelling in school, excelling in his behavior whilst in the care and custody of the JJC, but the state can't help but think if that would be the same case if he was not in the care and custody of the JJC at the time of this, or what he would be up to. Because although his criminal history seems on paper to be something minimum, it started to accelerate. And at such a young age, we went from joyriding, breaking into cars, running from police, to essentially orchestrating an armed robbery that ended in the death of another individual. I mean, the jump in severity of offenses in such a short time is astonishing to the state. The state agrees with Mr. Bookwalter that there are a number of factors that the court can consider in this case, which has been previously briefed by the state in Mr. Vaughn's case, laying out a number of cases, including the leg case, regarding factors that the court may consider, which are similar factors that the juvenile court considered in making its decision to waive. That being the severity of the case, whether he is beyond rehabilitation in the best interests of the community. The difference between Mr. Gibson and Mr. Vaughn is that there is a vast age difference between the two, whereas Mr. Vaughn, turned 18 years old shortly after he had entered his plea and upon his sentencing. Mr. Gibson is still much younger than Mr. Vaughn, so it does present a greater, issue for the court to evaluate and how that weighs in regards to mitigating and aggravating factors. I think I agree with Mr. Bookwalter that the
Try playing. If you play salty, you might win.
case is very serious. The nature and circumstances of the facts is very serious. I think he's demonstrated behavior whilst on probation that would show that he is beyond rehabilitation. And I think it is in the best interest of the community that he not go home today, that he continue on the process. It seems that whilst in the care.
Why are they, either of them, talking about him going home today? That's not on the table, by the way, at all.
And control of the justice system or the JJC, that's the only stability that he has seen in his young life. And I think for him to become a productive member of society, it's necessary for him to remain in the care and custody of the juvenile system or in the justice system altogether. I think to have him leave today or to sentence him and to send him home or to a probationary sentence would greatly depreciate the events of today. I do think a sentence found above, if the court deems it appropriate to sentence him as an adult, of 14 years is appropriate. I believe that the court can still sentence him to a sentence within the Department of Corrections if it deems so to do so through the juvenile alternative statute with a review upon his 18th or prior to his 19th birthday. As to the placement, I leave it to the discretion of the court, but I would ask for an extended executed sentence, whether in the Department of Corrections or through the juvenile system.
Thank you, Ms. Galvievski. I'm gonna let you talk in a minute if you want. But just so I have a consistent understanding with counsel, the way the court reads the juvenile sentencing alternative statute is that if the court elects to go that route, it pronounces a sentence. It then suspends the sentence, but that doesn't mean that Mr. Gibson walks out of this courtroom. When in essence, what essentially happens is if the court pronounces an executed sentence and opts to go with the juvenile sentencing alternative and suspends said sentence, what happens is Mr. Gibson will go down to Pendleton on the juvenile side. And he'll stay there until the IDOC notifies this court.
He can't get 40 years or 25 years, I think. It's robbery. He didn't pull the trigger. He wasn't the one shooting the gun. He was the one robbing them of guns. So it's 10 to 20 years, I think.
Prior to his, they notify the court when he turns 18, and we have to have a hearing before he turns 19, at which point the court can do a variety of things, which is it could modify the sentence, or it could just simply say, now Mr. Gibson is going to spend the rest of the sentence in the adult facility. That's my understanding.
Yes.
Is that your understanding, Mr. Bookwalter?
Yes, it is, Your Honor.
And yours, Ms. Galvievski?
Yes, if the court deemed to go that route, then of course we would have a review hearing. There would be reporting and progress
Correct.
reports from the Department of Corrections. Yes.
If the court were to decide to sentence Mr. Gibson as an adult, he would still go to the juvenile side at Pendleton or wherever until he turns 18 or 19, at which point he would then just transfer to the other side.
So I don't know what the difference is. So if he gets sentenced as a juvenile, he goes to juvie and stays there till he's 18, and then he goes to prison. And if he's tried as an adult, he stays in juvie until he's 18, and then he goes to prison.
That's my understanding. If he's sentenced as an adult, it's not like he gets stuck in prison with adults.
Right.
Yes.
All right, good. So we're all on the same understanding. All right, Mr. Gibson, is there anything else that you want to tell me?
Yes, sir. I have something I would like to say, and if I'm sorry if I mess up my words.
That's okay. This is not a speech contest. I see you have a piece of paper. Did you write something out?
Yes, sir.
If you want, you can read that. I'm not grading you on style points, Mr. Gibson. I just want to hear what you have to say.
Yes, sir.
So whenever you're ready, the mic is yours, sir.
Can you bring that closer,
And
please?
speak up.
Dear Your Honor, I want to start off by taking full accountability for my actions. I can't take back what happened or change the situation from occurring. I want to show you guys that I'm not the same person from a year ago. I thought the life I was living was cool and for me. Honestly, I was letting myself be influenced by the wrong things that I thought would make me fit in with people I thought was my friends. At first, I didn't understand or realize the pain and suffering that I was causing to people by doing the things I was and living the life I was. Your Honor, I don't agree with any of the things that happened, and I can't change nothing. The only thing I could do is right my wrongs and take accountability for my actions and take everything I learned from this situation and use it. I never understood the meaning of life and what there all is to see, do, and experience in life. I couldn't see myself in all the knowledge that I actually have. I look back at who I used to be and I realized what type of outcome the drugs had on me. I let them give me a feeling I thought was okay and normal. I am fully able to make my own choices and know what's right from wrong. The drugs is no excuse for my actions or what happened. I felt what I was doing at the time was my only option. I put myself in situations that I knew was wrong that would cause me trouble. Your Honor, this situation has shown me things I never wanted to see and go through, especially the families involved with this. It has brought a lot of stress, weight, and grief to them. There is no way I could give them back any of the time they've lost from this situation. My mind has been so twisted and lost since this happened. The kind of person I was with the mindset I had when this happened is all different. The way I look at things is different. I understand that things I do have consequences and isn't cool. I realize that if I keep on going down this road, it's going to get worse, and that's not what I want for myself. I have hurt too much people, including myself, by doing the things I was. I want to be seen and known for good and not a violent person no one wants to be around. I see the pain and disappointment in my family's eyes, and it hurts me to know that my actions have caused them pain and stress. I'm growing up and moving on from all the immature and negative things I was doing, and now that I'm thinking straight with a clear and right mindset, I have different goals and priorities. My biggest issue was that I didn't like to listen to what I was told. That still doesn't make the things I was doing acceptable or okay. The people I surrounded myself with were older and had nothing going for themselves. And they say you are what you hang around, and that's exactly what it was. I let everyone that cares about me down with my actions. I embarrassed them and myself. I want to show everyone that they didn't waste their time on me and that I'm going to do something with myself. Your Honor, I have learned a lot and experienced a lot with this situation. I'm finally at that point to where I know this isn't what I want to keep doing. I'm not perfect and I'm far from it. But I'm trying and I'm doing the best that I can, and I'm putting in the time and effort to change and be better. Things like this take time, and I'm willing to give it all the time and effort it needs. I'm actually seeing growth and maturity in myself. Everyone makes mistakes and messes up. We're human. It's going to happen. But rather we keep making the same choices on us. People learn from their mistakes and some don't. I'm one of those people who can say I've been there and has made mistakes, but I learned and didn't make the same choices as before. Your Honor, before closing this letter, I want you to understand that I talked a lot about my mistakes, but I don't want the word mistake to replace Dakota Gael Simmons because it was my actions that ended in tragedy. But I want to take this time to tell Dakota Gaeso's family that I truly do apologize, and not because I'm standing here today, but because I truly do apologize. That everybody that was there lost a piece of their life that they won't get back. Your Honor, I thank you for hearing this letter, and once again, I apologize to Dakota Gaeso's family and friends.
Thank you very much, Mr. Gibson. Seems lately I've been doing a lot of these sentencings, and it's just a shame that I can't have voice that's coming from you now talking to your peers on the streets before these things happen. Because I can say things in this courtroom, Ms. Golubievsky can say things, Mr. Bookwalter can say things, but I don't think that kids your age listen. They might listen to someone that's your age, but unfortunately they don't hear the message until they're sitting in that chair in front of their family, their mom who's weeping uncontrollably because of foolish decisions that were made. So, Mr. Gibson, the court did sit through this trial, and it did hear the evidence, and it did hear your testimony. And the court was well aware of how old you were at the time, how old you are now. You are very young. And I listened to you testify, and I get it. I understand how difficult it can be for someone in your position to do that. So I do give you a lot of credit for that, Mr. Gibson. I give you a lot of credit for the age you were at the time, the age you are now. These are mitigating factors, Mr. Gibson. What that means is these are factors that weigh in your favor. On the flip side, of course, there's Dakota Gallegos who died. And he was, I don't know if he was necessarily a friend of yours or how well you knew him. You certainly knew his associates. And as Ms. Golubievsky pointed out, you were kind of the link that kind of made all of this happen. And the court saw the evidence. I mean, the whole idea was to do this robbery from the get-go. And it was brazen. I mean, I think you believed, as the testimony came out, that no one would call the police. I mean, why else would you commit a robbery against people that knew you, whether you had a mask on or not? They knew you. They knew who you were. So it certainly doesn't show a great deal of clear thinking. I guess to some extent that's to be expected. You're 14
Thank
years
you,
of age at
Donald.
the
Thank you.
time.
Thank you.
But my children are slightly younger than you, Mr. Gibson. I think they know right from wrong. I think you knew right from wrong. When I consider the aggravating and mitigating factors in total, yeah, the aggravating factors, those are the things that are bad. You have a juvenile history. You were on probation at the time. I did read Magistrate Palanda's waiver order, and it does not seem as though you were taking advantage of the opportunities that were given to you through the juvenile system. The whole philosophy of the juvenile system is to try to step in and provide resources to correct
I did not need to know that at all. Oh,
behavior so that people don't end up sitting in adult court. That didn't work out so well. So the court does consider your juvenile history. It does consider the fact you were on juvenile probation at the time of the offense. You were on juvenile probation for what would otherwise be a felony. That would render this otherwise non-suspendable, although the court can suspend it if it
thank you, Donald.
elects to
Thank
go
you.
with the juvenile sentencing alternatives. This crime was committed in the presence of minors, many minors, and although you were among the youngest in the room, there were at least one, if not two, that were younger than you. And the court, unfortunately, had to hear testimony from most of those young people and acknowledges the continuing trauma that is going on in their lives, having witnessed someone be shot dead in their home. So yes, the nature and circumstances of the case is an aggravating factor. The goal of the robbery here, Mr. Gibson, was to get more weapons. That is an aggravating factor. As Ms. Galbieski pointed out, you were the common link.
Mesmerizing.
I'm not quite
Can't
ready
look
to
away.
say, but for you, this crime would not have occurred. But the fact that you were the common link certainly set a lot of these things in motion. In mitigation, again, we're going to talk about your age. You were 14 at the time. You are 15 now. At least the evidence that the court saw is that you did not, in fact, fire the fatal shot. And while that is really not legally significant, in other words, you are still legally responsible for what happened in there, the court at least acknowledges in this setting, in a sentencing setting, Mr. Gibson, that you were not the one that fired the fatal shot. You did cooperate with the investigation under difficult circumstances. You did so at a very young age. You did so in an environment that was very difficult. So that does show the court a level of maturity while you were incarcerated. You did have a difficult childhood. Now you're telling me that you didn't realize the consequences of your action. You have older siblings who are incarcerated, Mr. Gibson, correct?
Yes, sir.
I mean, I can't imagine how difficult that is to have to talk to your brother or sister while they're in prison, right?
Yes, sir.
So did that not resonate with you, even at a younger age, 11, 12, that maybe you should make decisions that were different?
Yes, sir, it did. But at the time, I took things as a joke, and I didn't take things seriously as it needed to be.
Okay. I mean, I note your conduct since. I understand it's not a very easy environment to be housed in the juvenile justice system. In many respects, it could be even a more difficult environment than the jail because you have a lot of people who are attempting to assert dominance or be the alpha in the room, what have you. So when I look at your conduct history, I mean, as recently as just a few weeks ago, you got reduced down to level 1. It seemed like you were doing well, and Mr. Bookwalter has calculated the percentages, but I guess I'm curious as to how you found yourself on level 1 so shortly after, right around the time we entered the plea, right? March 7th through March 10th, you were reduced to level 1. Why is that?
Yes, sir. We were playing basketball, and it wasn't intentionally. He had went to go and shoot the ball, and I went to go and bat the ball. I jumped in the air, and as he seen me, he moved his hand back, and my hand kind of like sniped his nose. And since everybody said it was intentionally, they said it was battery, and I got dropped to level 1.
All right, well, I do note that most of the time was spent level 3 or 4. There's also an explanation as to how these levels work, and it was explained that typically it takes about 14 days to move from level 1 to level 3 or 4. You had the administrative hold on March 7th, you were level 1 March 10th, you got elevated to level 2 on March 16th, you got elevated to level 3 on March 21. So we're maybe roughly consistent, a little bit faster. So I do give you credit for what you've accomplished since. Although you tell me you have A's and B's, I don't know what to make of these reports that say your on-target grade are D's and F's. Health, English, Earth and space science. Can you explain that to me, sir?
Yes, sir. Some of those grades aren't what they are now if the papers are accurate.
Well, they are dated December. I guess these are sort of progress reports. So it looks like it's dated October 15th on one page. It's dated December 16th on another page. I guess the most recent one shows on-target grades as A's, B's, and C's. So it's hard to read this, but I guess I'll give you the benefit of the doubt on that. I suppose, Mr. Gibson, have you learned the value of getting an education?
Yes, sir.
Here's how the court sees it, Mr. Gibson. You pled guilty, you accept your responsibility. I hear a lot of people say they accept full responsibility. Well, yes and no. In this case, Mr. Gibson, Dakota de Gallegos was killed. You're pleading guilty to robbery with a deadly weapon as a level 3 felony. So that doesn't quite encompass all the nature and circumstances of this case. But I'm not going to fault you for accepting a beneficial plea bargain that your attorney has done a very good job in getting you. I'm giving the plea, I'm giving your acceptance of responsibility, I'm tempering the weight by the significant benefit, but I am acknowledging that you have pled guilty. I'm giving you more credit, Mr. Gibson, for making the very difficult choice of testifying. That's where I'll give the greatest weight in my mitigation, that and your age. Offense for which your co-defendant, I believe I sentenced him to close to 40 years. Is that correct, Ms. Golubievsky? I think the PSI said 25, but
I think some
it
of
did
it
not
was
include the
suspended.
firearm enhancement.
Mm-hmm, mm-hmm.
Because I think Mr. Vaughn got 45 with 5 suspended.
Yes, because
Yes,
we
Sherry.
included a plea for the 2 and the firearm enhancement.
Correct.
Yes.
You were not charged with the firearm enhancement, Mr. Gibson, but make no mistake about it, your lust for firearms at an early age and your knowledge. If you know more than Mr. Blatt, you probably know more than the court about guns. That's not a good thing. I can only hope that your attitudes will change. The way the court sees it is this, Mr. Gibson. I have an opportunity here to give you a chance. It does not mean I'm promising you anything, but it does at least give you an opportunity to prove through action and not words what you're telling me here in court. As this works, Mr. Gibson, and I guess to be perfectly clear, I am going to sentence you under the juvenile sentencing alternative. What that means is this, Mr. Gibson.
So the lady in the back row is his mom.
And I know your mother is very excited, but she needs to listen very carefully, as do you. I'm not promising or guaranteeing anything I'm going to do. I'm going to give you a significant sentence because that's what this offense deserves. But I'm at least going to give you an opportunity, or Mr. Bookwalter, or whoever your attorney may be down the road, to make a pitch for me to reconsider what's happening. As it works is the sentence I give you, as I say, I'm going to tell you it's suspended at the end, but that does not mean you're on probation. You are going to Pendleton, okay? You're going to stay on the juvenile side. You're going to get your high school diploma. You're going to learn a trade. You're going to stay out of trouble. And what happens is when you turn 18, the DOC is going to notify me. They're going to prepare a progress report. And then we're going to have a hearing before you turn 19. And what happens then is this. I can make a number of decisions, Mr. Gibson. And again, I'm not promising you what the decisions are going to be, but one of those decisions is I could just frankly say, you know what? I think you should just spend the rest of the time in prison with the adults. That's one of the things I can do. I can take some of that time and say, no, let's not do that. Let's put you on community corrections. Let's put you on probation. Let's discharge some of the sentence or any combination thereof. Do you understand that?
Yes, sir.
As you sit here today, you should not expect anything other than when you turn 19 that you're going to be going over to the adult side. And that should be your mindset, because you need to do everything in your power to prove yourself that you deserve another chance. Do you understand that?
Yes, sir.
Like I said, I do think a significant sentence is warranted in this because of the facts and circumstances. The mitigation that I'm giving great weight to is justifying this court's decision to sentence you as a juvenile under the juvenile sentencing alternative. However, to be sure, the court finds that the aggravators outweigh the mitigators, warranting sentence above the advisory 9 years. So for that reason, Mr. Gibson, on your plea of guilty to count 2 armed robbery as a level 3 felony, the court accepts the plea, and again, finding the aggravating circumstances outweigh the mitigating circumstances, imposes a 14-year sentence. That is ordered executed to the Indiana Department of Correction. Now, I'm not going to put you on probation. That is the sentence. And as I said, as you see here today, you should expect that that's the sentence you'll receive. However, under Indiana Code 3134-2, I am suspending that sentence, and I'm ordering you to the custody of the Pendleton Juvenile Correctional Facility. Mr. Gibson, you are awarded 452 days of Class B credit against that sentence. Your successful completion of placement at the juvenile facility is a condition of the suspended sentence. The Department of Corrections, Youth Services is ordered to notify the court when you turn 18 and will be ordered to prepare a progress report at the time for the purposes of a review hearing, which must be held prior to your 19th birthday. And again, upon receiving that report and setting the hearing, Mr. Gibson, I will consider what modification, if any, would be warranted. Do you understand that, sir?
Yes, sir.
Do you know what you need to do?
Yes, sir.
Have I said anything today that is unclear or that requires further explanation?
No, sir.
All right, Ms. Golubievsky, there are remaining counts, ma'am.
The state would move to dismiss at this
All
time.
right, so ordered. Mr. Gibson, you are only 15 years of age. You've been incarcerated now for 452 actual days. I'm going to find that you're indigent for purposes of court costs, public defender fee. Have I missed anything, Mr. Bookwalter?
I don't believe so, Your Honor.
Show your appearance withdrawn.
Well, why don't you just leave me on it?
It's going to be a while, Mr. Bookwalter.
Well,
I'm happy to do that if you'd like.
I may not be here by the time it comes back. Let's put it
Well, I
that
certainly
way.
hope you are. All right, Mr. Bookwalter, I will leave you on the case, and that will allow you to continue to keep the court apprised. It's going to be a while, Mr. Gibson, until you're statutorily eligible to come before the court again. But Mr. Bookwalter will be able to provide further assistance for you, okay?
Yes, sir.
Ms. Golubieski, have I missed anything?
I don't think so, Judge. No.
I suppose as a condition of the sentence, I don't know if it's in the plea, but I am issuing no contact order. You're to have no contact, direct or indirect, with Mr. Gallegos' family. I suppose that it should also extend to the
I can't
Minors
type
in the
anymore.
minors in the home, one of which was your ex-girlfriend.
Yes, sir.
She's not your girlfriend anymore, right?
Correct.
Well, if she is, you're going to be breaking up pretty soon because you're not going to be having any contact with anyone in that household. You understand?
Yes, sir.
All right. Now, Ms. Golubieski, have I missed anything?
No, I don't think so.
Was there restitution? There's no documentation.
No, just like in the prior
I feel like
case.
we had addressed this in Mr.
Yep,
Brown's
the
case.
family is not requesting any sorts of restitution or anything.
All right, Ms. Reed, have I missed anything? All right, Mr. Gallegos, I've done what you've asked me. I've put the ball in your court. The rest of what happens is up to you. I make no promises. We'll see how you do.
Yes, sir.
Good luck.
Yes, sir. Thank you.
Okay, I think that's the last of the gang. I think we saw them all now get sentenced. His was the worst hearing, I think. He got the latest sentence, though. All right, let's go to someone who is definitely innocent. Guys, innocent.
Daniel Laflur, 49D 362603C M009279. Laflur, pretrial conference in person, out of custody.
Good morning, sir. And you're represented by Mr. Duplantier. Mr. Duplantier, how can I help you with Mr. Lafleur?
Good morning, Judge. This is a relatively newer case. If we could just get a new date, we would request discovery and an offer. And then, Mr. Lafleur, I just need your number. Hold on, Mr. Lafleur.
No, ma'am.
Hold on,
I got the proof that
Mr.
I'm
Lafleur, don't
innocent,
say
ma'am.
Mr.
No,
Lafleur,
no.
Hang on.
I need to explain to the judge that I'm innocent.
Sir, hang on.
I got a
Gentlemen,
Sir.
gentlemen, Mr. Lafleur, can you hear me?
Yes,
Okay.
ma'am.
So, Mr. Lafleur, you and the court has already entered a not guilty for you. You don't have to tell me you're not guilty. It's already been entered.
Ma'am,
So,
I got the whole criminal expungement
Mr.
and a
Lafleur,
copy of the FBI
Mr.
letter.
Lafleur, would you listen to me, please?
Yes, ma'am.
Today's hearing is just a pretrial conference. It is not for me to take testimony or hear any evidence. So the only thing I need to know from your attorney today is what date he wants me to reset this for so that you will have it, because this is a pretty new case.
Ma'am,
And-
these people are trying to set me up, ma'am.
And Mr. Lafleur, I don't want you to say anything that could incriminate yourself because the deputy prosecutor is on the line with us. So I want to just talk to Mr. Duplantier right now. So hold on a second. Mr. Duplantier, how can I help you?
Yes, Judge, can we just have an attorney's conference in due course? And then, Mr. Lafleur, I'll talk to you about everything today, okay? I just need your phone number so we can get in contact.
So, Mr. Lafleur, what's a good phone number for your attorney to reach you by?
317-372-0.
Okay, 317-372.
Yes, ma'am.
All right. And do you have your attorney's phone number?
No, ma'am.
Okay. Do you have a pencil and paper right there? Or Ken, are you going to write this down for Mr. Lafleur?
Yes, we got it. Ma'am, I feel like can you hear me for 1 second, ma'am?
Well, hold
Mr.
on.
Lafleur.
Hold on one
Mr.
second.
Lafleur.
What, Mr. Duplantier, what's a phone
Don't want me
number
to
for you?
talk.
My phone number is 3.
I couldn't hear you, Ken.
Yes, I got it.
Okay.
And
So,
Mr. Lafleur,
I edited the attorney's number out, not his, but I think I muted it. So you didn't hear the last few, but maybe not.
understand we're going to talk about everything, but you have the right to remain silent. You should use it right now, okay?
I did nothing wrong. I got the whole criminal expungement and the whole
Sir,
copy
you
of the FBI clearing me to carry guns, to buy guns. Y'all took a gun that's registered to me and charged me for me having.
Sir,
Well,
This is not-
now you just confessed to having a gun. Good job, sir. Excellent work on your part.
you
Right.
should. For right now, we can address that
This ain't
later.
right.
Okay.
It's not right.
All
I
right,
brought
sir.
the truth. I brought the truth with me.
Mr. Dupontier, I'm going to set Mr. Lafleur for a pretrial conference on June the 9th at 8:30 in the morning in person. And Mr. Lafleur will see you on that date and time.
Yes, ma'am.
All right?
Yes,
All
ma'am.
right, and your attorney will be here then also.
Thank you, ma'am.
You're welcome. Have a good rest of your day.
Thank you, ma'am. You too.
You're welcome, sir.
I'm glad I don't work at a courthouse. Oh, what didn't we do yet? We got one more. This guy. We're in Wisconsin, guys.
We have our next person, Matthew Mayer, here with referred charges of misdemeanor bail jumping, possession, drug paraphernalia, possession of THC. I have received a copy of the probable cause statement. Probable cause was found by Judge Dietz. Mr. Mayer, it's my understanding that you did not wish to speak with the public defender this morning.
I tried to, and he doesn't understand what I don't have a mailing address means. He kept repeating the question, what's your mailing address? What's your mailing address? I don't have one. I'm homeless. So instead of arguing with him over the fact that I don't have a mailing address, I just got up and walked out because obviously he was not willing to understand or accept the fact that not all people have a mailing address. And how am I being charged for THC and all of this when everything that I bought and everything that I had when I was arrested passed the 2018 Farm Bill in the state of Wisconsin?
Good guy. Another one confessing right there. Good job.
For legal marijuana sales. I bought everything that I had on me from a...
Even if they had video of me buying it from a undercover cop and it was in my hand on the video and I hold it up to the camera and I say, oh, mine. In court, I would say, no, I didn't have nothing. I don't know what you're talking about. I didn't have none of it. Prove it.
state legal dispensary in the city of Manitowoc earlier that day. So I don't understand how I can be charged with any criminal possession of anything that was sold under state law guidelines for the state of Wisconsin regarding marijuana.
Well, Mr. Mayor, you can contest the case. We're here for a bail hearing today. What is your phone number?
I don't have one. I am homeless. I have no finances. I have no address. I have no contact.
Judge, please ask him for his address next. Please. Please, I'm begging you. Please.
Information. My fiance has a text now number on her phone that I don't know, and I have no way to get in contact with to even let her know that I'm in jail right now.
Your fiance?
My PO would be the only way that I could be there is no, I don't know how to answer that. I really don't. I don't want to be forced to stay here because I have no contact information, but I don't.
Thank you, Kelly.
Until I'm able to talk to my PO and see if I can use the PO's office as a number, I don't know what I can do.
Mr. Mayor, who's your PO?
Jake Pashik.
What was the first name? Dick?
Jake?
I
Okay,
think
is your
that's
birthday September 23rd in 1981?
Yes. All the information y'all have for me is correct.
How do you intend or how are you able to get yourself to court?
I've been making it for court for my other paraphernalia that I have. I have a paraphernalia case going on. I've made it to every court date that I have. Because we just checked, my fiance goes on her phone and checks up the CCAP thing to check when I have court. And I have made it to every single appearance for it. I have not missed a single one for that. I have court coming up again in like a month and a half for that. She knows where it is. I'm horrible at keeping track of this shit. Pardon my language. I apologize. But I'm horrible at keeping track.
I apologize for any of you who are offended by his language.
Of this stuff. My fiance is amazing at it. She makes sure that I am at court when I need to be on the correct days, on the correct times. And like I'm saying, I've been to, I believe, 3 different court appearances so far on the other charge. I haven't missed a single one. I haven't been late. I haven't had to call in to reschedule. I've showed up in person for every single appearance. Just because I don't trust that Zoom shit. I'd rather be there in person than have something go wrong.
Mr. Mayor, you really cannot keep swearing when you're in court.
I apologize. I am sorry.
Do you have any employment or income?
No, I am homeless. I live in a tent behind a church.
Okay.
I wish I
Officially, I'm saying this whole fiance thing is a bunch of bull. He ain't got no fiance. He just doesn't have a fiance.
did. I've been looking, but I cannot lift over for extended periods of time because of my back issues. I cannot lift or carry more than like 30 pounds for extended periods of time. And being my lack of skills as a laborer, that really, really narrowly limits down my job opportunities.
Correct, Bren, correct.
Okay, thank you. I'm going to turn it over to the other attorney for his recommendation. Attorney Barrows.
Oh, I'm bleeding again. Yeah.
Commissioner, the state understands the defendant's situation. However, somehow he needs some information for the court to have hold of him, Commissioner. Looking into the defendant's 25 CM 469, it shows that his attorney was not able to get, this is DA's notes on my file. Attorney was not able to get a hold of the defendant. Likely the case will be resolved with a stipulation, Commissioner. It's very concerning that the open case is the same type of offenses or charges that is before the court here, Commissioner, which especially he is violating his bond conditions. Looking at the defendant prior records, the state found since 2018 had 3 warrants, 2018, 1 2019, 1 2022, and 1 2025. If the court wants, I can read the case numbers, which shows that the defendant already has history missing in court. The state believes some cash is appropriate. I understand. But from right now, we have Mr. Appeal Court, a bail jumping, some type of offenses. With that, Commissioner, 2 cases are open now, or potentially the second one. Small amount of cash is appropriate with conditions of an absolute sobriety. And also, the defendant should give any type of information after release from, if he posted a cash bail. Thank you.
I have a mailing address. I forgot that we were told the warming shelter here in Manitowoc When they closed for the season, they gave us an address that we can use for mail and other purposes of being.
Every time he says that, we take a shot. That he's allowed to use that place for mail because they gave him permission. Shot. Get a big bottle ready.
In touch with. I completely forgot. I just remembered and asked this gentleman, Sergeant Ott, to look up the address for me, if that'll work. We were told by the pastor of that church that we can use that address when the warming shelter closes, so we still have a place that we can receive mail and letters.
Okay.
So if that would be a viable address to where I can get a signature bond or something so I can still get out and try to function out there, I have an address. He just looked it up for me because I couldn't remember. My dyslexia wouldn't let me remember where the two went.
So do you have it? Would you like to provide it?
Oh, what was it again? 502 North 8th Street. The pastor of that church.
That is not his home address. That is an address of a shelter that run by the church, I believe.
Church told all of us at the warming shelter when it closed that we were allowed to use that address for mail purposes because the warming shelter is done for the season at this point. Pastor Matt is a good man. He's helped out before. You know Pastor Matt? Sorry. But yes, he stated to all of us that we can use that as an address to get mail at.
Thank you.
I'm sorry, I was trying to remember before and I couldn't remember what it was.
It's tough because the court does expect people to be able to be contacted through the court, either through mail or ideally where you're residing. But if you're not residing anywhere, you can't provide an address like that. And if you don't have a phone, nor can afford a phone, you can't provide that phone number. In this situation, that Mr. Mayor appears to be having a hard time, doesn't have stability in his life, which makes it difficult for a person to comply with conditions of bail, to comply with conditions of Department of Corrections, that we have the probation hold.
We're about to get a lot of mail soon. We're about to get flooded by mail soon.
Also makes it harder for someone to attend court. I do also see that no matter what bail I set today, there are two other things holding Mr. Mayor in the Manitowoc County Jail. We have that Department of Corrections hold that's been referenced, as well as a commitment, which is what I think initiated this contact with law enforcement, is they saw that he had a commitment open.
I don't know what that is. Sorry, I don't know.
Given those other holds, I'm going to set a $1,000 signature bond with the condition to maintain absolute sobriety. That's no drugs, no alcohol. And you can contest this, but law enforcement did a test and it tested positive with an illegal substance in Wisconsin. It'd be best for you, your situation, your pending court, that even if you believe someone's selling you something that they purport to be legal, you stay away from all of it. It's not good for you. Not good for your situation. Unless you have a valid prescription for something, then obviously, then that can be in your possession. The initial appearance is May 7th, 2026 at 10:30 a.m. in B15 of the Manitowoc County Courthouse. You must attend that court date if you are released prior to then. Failure to do so, a warrant will issue, and you must follow the conditions of bond, or otherwise you're going to face further charges, and you have the right to representation by counsel. If If you want to see if you qualify through the public defender's office and have them assist you through it again, you do need to now contact them and get signed up through that. And we are adjourned in that case and off the record.
All right, guys, that's what we got for today. Whew. A lot of people are innocent in jail. I know this because they tell me loudly. Which we had a lot of shots today. Shots fired. Thanks for coming out. I really, really appreciate it. It's Saturday. It's the weekend. Go do something fun. I think tomorrow I'm going to do something fun. Don't worry, I'm still going to make it to the live stream tomorrow. No stream tomorrow morning. It's tomorrow night. But I think I'm going to go watch that new Billie Eilish movie. Hit Me Hard, Hit Me Soft, or say Hit Me Soft, Hit Me Hard. One of the two. I'm taking my daughter. She loves Billie Eilish. So, I don't know what it's about. But I know there's popcorn. Movie theater popcorn. 0 calories, I think. That's the way that goes, right? Thank you for coming out. I appreciate it. I hope you guys have a great day, and I'll see you again soon. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her style is classy. She's always top shelf. Don't take my word. Come and see for yourself. Her cases are new with a twist or two. I really like them. I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf. Join in the laughter. Come and see for